Welcome to Talking Security with Caliber. I'm Tab Pierce. This is my co-host, Chad Butler. Chad and I are doing something that I don't think many people are doing, and that is that we're kind of, well, I don't consider us competitors, but collaborators. And Chad has a company called Mission InfoSec. So we'll give you information kind of at the end of this so you can reach out to us or reach out to him. But Chad and I go way back. And we're excited about, I'm excited about having you as my podcast co-host.
This is fun. Thanks for having me.
Yeah, man. Thank you, bet. Thank you. Today's guest, our first guest, is Karl Reid. And Karl Reid goes way back with me from our 14 plus years at Caliber. And I'm excited to have him on, talk about just some different things than we've talked about before. So, welcome, Karl. It's great to see you. Great to have you on the podcast.
Welcome, Karl.
Hey, thanks a lot. I really appreciate you having me on today.
Yeah. And Karl, I think you said this is your first podcast, right?
This is my first podcast. Yes.
All right. Well, I say that because I want. It's just kind of always cool to like have the person on their first one and like that. And so excited to have you here. And like I had said, Karl and I go way back, and just I've seen some of the things that he's been doing and posting and whatnot on LinkedIn. And I thought that based upon some of the things that we've talked about in the past, which is really sometimes heavy technical security, that this is kind of different. And, so Karl, you talked about some of the new, I don't want to put words in your mouth, but as we had these discussions about some of the auditing, some of the SEC rulings, some of the requirements that an executive might have or a board member. So why don't we start there? Why don't we start with you kind of giving us an overview of the things that we talked about?
Okay. The real thing is that Enron kicked off years ago. Enron kicked off what the SEC and the Congress put together, the Sarbanes-Oxley Act in 2002, and in 2004 the company started having to comply with that act, and the rules have changed over the years. But one of the things that has changed this last year was that the CEO and the CFO and the audit board and their roles are changing, and they're going to have to take a more active role in understanding the risk management of their company, and they're going to have to be trained. And there's a lot of changes going on, and back in August, Sue Bergamo and Mike Wilkes did a nice little conversation around those rule changes and what the C-suite and beyond is going to have to be looking at, because these rules are going to have to be complied with. And so they had a nice big discussion around it, and it looked like it garnered a lot of global interest, because these rules do affect global companies as well. And so one of the things that they talked about was what constitutes materiality, and they kind of decided that materiality is got a few changes to it. A lot of people think that materiality is just about the dollar figure. Well, it's not just about the dollar figure. It's also about the perception of what the investors think. Do the investors, if they don't have the information, they can't make a decent decision about the company. So if the company doesn't report things that happen to them, and you can see it in a lot of the 10Ks, they don't have any mention of any breach, haven't for years or whatever. And in actuality, the investors have been, in my opinion, investing in these companies and kind of in a vacuum in a way
Mm.
because nobody's talking about it. And and a lot of times they say, well, what's material? Well, it's not just that dollar figure, and it's not just the people that are in charge of the breach investigation that determine that. You see, so what happens is there needs to be a bigger panel. The audit board needs to be involved in this to determine is would a reasonable if we report this, would an investor really gain a lot of information from it, and would it be impactful to them? And so since the CFO and the CEO are in charge of their internal controls, they've even got to take that more active role too and understand what's happening in their company, especially when it comes to breaches. And we're seeing these breaches happen every day now. This past weekend, we saw the CrowdStrike.
Hmm.
Uh, wasn't a breach, but it was an event that people's websites went down. And guess what? When they went down, they're going to have to disclose that because some of those companies probably lost millions of dollars by noon. You know,
Yeah.
so that's kind of where we're at, and this needs a deeper dive, honestly, on to you know what these requirements are and how these people are going to how these companies are actually going to report these things.
And I think it's interesting. You said at the beginning, I want to go back to that. You talked about the Enron case, and I think that was really insightful because what I've seen, and what you're talking about, just for those who aren't aware, there's been a lot of movement in this space where now if you have a breach and you're a publicly traded company, you have to report that to the SEC if it reaches certain guidelines, right? If it reaches that materiality definition. But the Enron case, like that was a really watershed type of moment, and I see sort of two camps on this. One, people are wringing their hands like, oh my gosh, CISOs are publicly accountable to this. They're going to be thrown in jail if they say the wrong thing. And then I see other people who have maybe been around the block a few times or been around a little bit longer that are saying, no, this is actually a good thing. This means cybersecurity in general is kind of maturing. And this is an opportunity to sort of elevate that to maybe perhaps the same level as we see with like financial accounting and reporting and gap measures and such. So it's interesting. What do you have a take on that? Is this going to lead to better things, or is it all doom and gloom like you see some people talking about?
Well, no, it's not all doom and gloom. The whole thing is that the companies want to be better informed, right? So if you hide these things from them, this is gonna you're gonna wind up, if it does come out later by a whistleblower, and a whistleblower is a protected employee for SOX, right? So protected employees are anybody that reports what they reasonably think is a rule broken, by the SEC rule that's been broken. If they report it to their supervisor, if they report it to law enforcement, anybody in that's basically got any supervisory uh, authority over that employee becomes it becomes a protected employee. And so if they don't report it to the SEC, what happens is that that employee has the opportunity to go to the SEC and say, look, I know something that happened and I know that the rules were broken. And then guess what happens? If that gets out and the company didn't talk about it, they didn't report on it, they didn't do anything to, protect that employee, then what happens is you wind up with the potential for, class action lawsuits against the company for, misleading the investors and things. So it can become a nightmare for the company. And nowadays, if a data breach, I know we didn't think about talking about this, but privacy is another one, right? So if the data gets out and it's a lot of, let's say, customer data, right? Well, that customers, if your customers are worldwide, you might be affected by GDPR. You might be, it might be CCPA if they're California. It might be the New York Shield Act. There's all kinds of things that could bring you down. I mean, 4 people from New York could be $1 million because the max I think is $250,000 per incident of data that's been exposed, right? So you could reach large numbers of fines, for privacy just in that sense. See, you can see the can of worms that can be opened up here. See what I'm saying?
Yeah. Hey, so there does seem to be a gap between what an executive, a CEO or a CFO or a COO, what they're doing right now, and their understanding or knowledge of what they're culpable of, or what they're basically agreeing to, right? They may think, hey, I have a CISO, and so the CISO is my buffer, and so which isn't the case, right? And so if things are changing or
not anymore,
but and that's great. I'm glad you interjected the not anymore. Even if it isn't anymore, is there a grace period, like okay, you know what, now we got to get all these executives on board, make them realize it, or is it like flipping a switch and it's an incident, and it's like whoever's the sucker that gets caught in that incident they're going to be like, oh, you're the guy that brought, you're the executive version of Enron, right? In the future, when we talk about it in 20 years. I mean, is it, how do we get everybody up to speed, I guess, is the question.
It's podcast. Honestly, Tab, it's like through podcasts like yourself, Sue Bergamo and them did their thing with that. That was back in August of 2023. They were warning you then, see, but December 18th or the 15th or 18th, somewhere around in that range, that's when the rules, it's so many days after the Federal Register comes out with the new rules that it becomes effective. So basically, this 4-day that Chad mentioned, the 4 days that they have to determine materiality and report it to the SEC, that 4-day period is in effect right now. So basically, if you don't see people reporting this stuff within 4 days, like that thing happened last week, so we should be seeing people filing 4Ks against, not 4Ks, 8Ks against this cybersecurity incident that we had, and that's the new rules, and they're in effect right now, and the whole thing is that the boards are going to have to be educated. So that means training material is going to have to be spun up. There's a lot of opportunity for growth in this industry because somebody's got to take the reins and say, we're going to have to. Your role on the days of being a member of the audit board and just having your name on the paper and having it on your resume that you're a board member, those days are over. You're going to have to take a more active role now and be educated and start making some serious decisions with these companies. Yeah,
it's almost like ultimate FUD. Yeah, we've reached critical FUD.
Yeah.
Anyway,
but I think I think InfoSec teams are going to have to take the lead to drive a lot of that education. So one of the transitions that I've seen is, it used to be InfoSec teams were very careful about the wording they used. Don't call it a breach until we absolutely know it's a breach. We're going to call that an investigation or an incident, or, and you see a lot of things that in the court of public opinion, you're like, yeah, that was a breach, and they'll swear up and down that it was just an incident. It didn't reach our categorization of a breach. But now it's like, was it a breach and was it material? And that's like, you made the point earlier, a CISO saying, no, that wasn't material, so you don't have to worry about it. I don't think that's the CISO's call anymore, right? Because that's a very specific term.
You are
yeah.
You are absolutely right. You are absolutely right.
And I think the smart CISOs are not going to make that call.
I certainly wouldn't. If I was, I wouldn't. That would not be my job. This is going to be who puts their name on it. Remember, we asked about that earlier. We talked about that earlier. It's that CFO, that CEO, the COO, the general counsel, the audit board members. They're all going to have to come together and say, is this materiality? And understand that the FASB, that's the back in 1999, they already said materiality is not just a dollar figure. There's more to it. There's an aggregate of things that happen. And it's that perception of the investor. Does a reasonable investor think that it was material? And those are abstract things that, man, you're just better off to talk about this breach that happened and say, look, we're strengthening our controls. We're doing everything we can to stop this from happening ever again. There's a lot of things that are going to have to change on these publicly traded companies. And there's going to be some suffering, and there's going to be some wailing, and there's going to be some gnashing of teeth.
So COO may actually ultimately be COO, right? If that happens. Yeah. So you said there's something key you said, right? You said publicly traded companies, right?
Yes.
So what if you're a privately held company? Are you okay?
Yeah, you're not having to report to the SEC. Okay. Things.
Yeah. So don't go public. I think that's the.
But a private company could.
Don't go. Yeah, don't go private. Anyway,
go ahead, Karl.
Well, a private company still may have internal investors that can still hold them accountable and say, look, they're still liable for suits. I would imagine.
Yeah.
I'm not a lawyer, but I would imagine that if you were privately investing in a company and they did wrong, that you could file a civil lawsuit or a criminal lawsuit if you felt like it was criminality involved.
And there's still, as you mentioned earlier, the privacy regulations, those are still in force for private companies. And your point about whistleblowers. Yeah. So I had an experience recently, not that recently, but speaking with a customer, I was advising them to do something and they were like, no, we can't do that. Can't do it now. Is this required by, XYZ privacy legislation? We'll say GDPR for the lack of a better term, or for just to make it a little bit more specific. And I spoke with a lawyer and I was like, hey, I've read GDPR. I can't see anywhere that says this thing needs to be built. What do you think? And they were like, well, basically what it boils down to is if somebody submits a complaint and it goes to the ICO and they look at it and say, well, you really should have done that, then you're culpable. And so that whistleblower case, that's a real concern. Even if you feel like you're doing everything right and you get a whistleblower submit something, and then it goes to the governing authority, whether that's the SEC or the ICO with the GDPR or PCI or whatever, then it's kind of up to them, right? Like, did you do the right thing, and were you above board on all of this? And if they judge no, then you're on the hook.
Well, here we are as professionals. We've got the CIA triad that it's like a three-legged milk stool, and if you what we saw this weekend was that the availability wasn't there, so that three-legged stool fell down, right? And so now we don't know what all ramifications this is going to have, and we'll see what happens. But if anybody whistleblows over that, I don't think that there's going to be anybody whistleblowing over it because it was such a big deal. But it did affect financials, and you understand that's a significant amount of, if your site was down for a day and you're literally making millions by noon, and you weren't making millions by noon, that's materiality. And I know I'm saying that's materiality just from a from a financial number, but the other things are the aggregate of all of that, the total mix criterion and that substantial likelihood criterion all comes to play. That investor's going to want to know, was that because you didn't test that update? The investor's going to want to know, or even the Barron's people are going to be asking some hard questions on that next earning call. Follow me?
Mm-hmm.
And
Yep.
they're going to have some good answers, because technically, I mean, I remember the day when nobody pushed a patch on Friday because you didn't want to have any kind of incident on, working on the weekend. See what I'm saying? And now
Yeah.
we've gotten to this, and I know it's maybe the agile mentality is not the way to go with this, but we're trying to do things faster. We're trying to get things out the door faster, and just take the time to test these updates to your system. And I know we should have been not trusting CrowdStrike at this point, but here's the deal. We're going to have to go back to that old way of thinking that says, yeah, maybe we should, before we test this out, maybe we should see if there's a reaction before we just slam it through. Slow down a little bit.
Yeah. I think there's going to be a lot of people that shut off auto update, and like
Absolutely.
maybe we won't be doing that. Hey, so, question I have for you, Karl, is I guess my view of most things is what's the opportunity, right? Like what it's like. Kind of like never let a good catastrophe go to waste kind of mentality. And so looking at it from an entrepreneur's standpoint, does this, or is there a potential for a new position to be created inside of a company, right? That is basically I am, or that particular person is the liaison between executives and everybody else to make sure that they're kept good. And then the other question is there an opportunity for somebody like yourself to run around going, like the SEC is coming, the SEC, like the British, the SEC is coming,
Right.
where you can create a groundswell of knowledge or opportunity based upon a lack of awareness that those individuals have.
Well, I do see an opportunity for speaking engagements, and I know it's going to create work for the board, and there's a lot of board members that maybe don't want to work. Maybe they do. I don't know. Maybe
Mm-hmm.
they want to get involved, but we've certainly got to present the opportunities to them and see what happens. I'm in the process of building some right now. I'm in the process of building some slide decks that would help. Or maybe I turn them into podcasts. I don't know. Maybe I
Mm-hmm.
turn them into a YouTube channel that you subscribe to. I don't know yet, but I know that there's going to have to be an education of the board. There's going to have to be education of possibly even CEOs and CFOs, because maybe they have been so hands off that they don't understand risk management at all, and it may be back to basics for a lot of people. And that's, I think there's really some good opportunity to be able to educate the boards, educate the C-suite, and work with them, because you can't kill the messenger.
Mm-hmm.
That's where you get into a problem. If you kill the messenger, they're going to go to the SEC and they're going to go, hey, you're breaking the rules left and right, and then you wind up having to fight that battle when you should have just said, look, let's tackle this thing. The guy that's screaming this stuff is right. and he's a protected employee. We can't really do anything to him, but you know, let's take his advice. There's a lot of rules changing every day. Privacy's changing every day. Every day, some state here in the United States creates a new legislation that says we're going to protect the rights of our. And you can go out to the SEC. You can go out to all kinds of different sites and find out what's happening all over the United States and basically all over the world now. It started with GDPR, and then all the states jumped on and said we're going to get our share too. And literally, some of these privacy things could bankrupt a company in a heartbeat. And if we don't start tackling these challenges that we have and start protecting the data in a lot better fashion, I guess maybe that's not the right word, but it's our obligation to protect it's our
More
obligation to
awareness.
protect
Yeah, more
and have
awareness.
more
Yeah.
awareness. And this training is going to be really important. And I just haven't figured out how I'm going to deliver it yet. But I plan to, maybe do speaking tour. Certainly this is my kickoff on your
Yeah.
podcast.
Yeah.
you know,
And we can say something I didn't.
Yeah, I think the other thing to think about is, the fuse is so short on these filings. What, is it 4 days that you have to file these?
4 days. Yeah.
And
4
and
days.
so if boards and C-suites haven't started thinking about what constitutes materiality, you're not going to be able to determine that in the amount of time that you have to file that without being penalized. So, I think that's a
Right.
big message from this is you need to start having those conversations. What's important to our business, what defines or what constitutes a material breach, and how do we determine that? And there's going to be some variability with each incident, but if you haven't at least started thinking about what constitutes materiality, you're certainly not going to be able to do it in the space of 4 days with any sort of accuracy. So,
Right. And
prepare.
you're just basically behind the power curve starting off right now. I mean, it
Yeah.
is literally already in effect because December 15th or the 18th, I can't remember which date it is exactly, but there's some, anyway, it happened in late December, and these new rules kicked into effect, and you need to start thinking about them if your company hasn't done that. So,
Yeah.
So I'm going to ask a question that you can't possibly know the answer to, but just
okay.
play along with me. What percentage of executives or C-level in a private or in a publicly traded company do you think knows what they need to know? I mean, like has the awareness of this? Do you think it's like, 90% know it, or maybe 0.9% know it?
Are you talking about awareness that it's a thing,
Like
or
it's kind of like the Titanic? It's like, hey, the first guy sees an iceberg and it's too damn late. You know what I'm saying? I mean, it's like I'm
Right.
saying
Yeah.
were there like that? I mean, how? Because if this comes at them, hey, we didn't know is very much like an iceberg, right? It's like, the iceberg doesn't say, okay, sorry, we'll just kind of scoot out of your way.
Yeah.
Right.
There you go back to you can't plead the Enron.
Yeah.
Ignorance of the law is no excuse. What's that? That's the old saying, right? Ignorance is no excuse. Um, Ignorance of these SEC rules is no excuse. Yeah, I mean, you've got some public traded companies have law firms that have dedicated people to understanding what the requirements are. If you've got such a legal counsel that is not keeping up with all the changes to the SEC rules and not informing you, if you think that the CISO can make the decision of materiality or the internal audit director can make it, then you're barking up the wrong tree because it's going to be a collective now, and that's what the SEC is trying to enforce.
Yeah.
Is that you have a bigger suite of people that are involved in the decision making. You have educated people on the board that are helping you make these decisions, and ultimately it's that CEO and CFO that puts their name on that certification. And if they're pleading ignorance, then they're basically signing a false,
Yeah.
certification,
Yeah.
because
Hey,
they're required to know the state of their internal controls.
yeah, and we've got just a couple of minutes left, and that's actually like a perfect way to end this. Exactly what he said.
Yeah.
But do you have anything to add? Because I've got one little thing to add, but I want to see if you've got something. Okay, but I just wanted to give you that the thing that I think about, Karl, is how much companies are going to need this, and they don't know that they need it right now. And
You're exactly right.
So I look at a person like you, and you're the kind of guy that the company needs, the guy that is aware of what that risk is, and that clarity of mind that an executive is going to need. So hey, you can accept the risk, but we need you to understand 100% what the risk is, because you can't, we don't want you to accept a risk because you just don't know that the risk is there. So I think.
Look,
oh, go ahead.
well, look at it this way. Let's say that risk, let's say that you've got a risk program, but it's like a street light in the parking lot. It's shining down on the parking lot, right? But the risk doesn't appear inside that spotlight. It's actually out in the dark of the edges of the of the parking lot.
Yeah.
What you've got to do is see that whole parking lot. You can't, and that's where I come in. I help companies see the whole risk. I think about things that other risk analysts don't.
Yeah.
Maybe there's people that are better than me. Maybe there's people that are worse than me. I don't know, but I do know that I've been doing this for 24 years. With this socks company. I mean, this socks for 20 years now, because I started in 2004 with Northrop Grumman and their mission systems and their space technology, and I got them through their SOX compliance, and I've been doing it ever since. And, I've worked for Boeing, I've worked for Microsoft with you guys, and I've worked on Semantic, you name them, I've worked with them all.
Yeah, and I think that I'll give you a chance to let people know how to get a hold of you, but I definitely think if there's anybody out there that's that is in a privately held company, or other company, but that wants that level of clarity, they've got to be able to have somebody like you to reach out to. So that's your plug. How does somebody get a hold of you? Like an email or a phone number, or whatever. I think those are probably it.
My email is jkarlreid@outlook.com.
That's a Karl with a K.
Karl with a K, yeah. jkarlreid@outlook.com. I can certainly attest to the fact that I've been doing this for 20 years plus, and it's kept me. That's been my bread and butter. SOX really been my bread and butter and ISO certifications and all of that too. But primarily it's been SOX compliance.
Yeah.
And there's a lot to know about this, and you need to have somebody on your staff that's knowledgeable about SOX and the SEC rules. And a lot of times your legal counsels just tap so much they can't keep up with it at all.
Yeah.
Well, now, cool. That's not to say that I don't need that. I'm not a lawyer, and I may interpret things wrong, but that's where we bring in counsel to help with those discussions. You certainly don't shut down the discussions.
Yeah. Well, Karl, thank you very much, man.
Thank you for having me.
Yeah, man, really appreciate that. I do want, Chad, how do people get a hold of you?
Yeah, missioninfosec.com or email just help@missioninfosec.com is the best way to get a hold of me.
Is that help with an exclamation point or just help?
Just regular.
Just help, okay. And if you want to reach me, you can find us at Caliber Security. And I'm not help at Caliber Security. I'm just tab at calibersecurity.com. And just want to thank both of you. And that's probably the last time I'm going to thank you, because you're going to be with me on these all the time. So it's just, but Karl, thank you for joining us. And man, just appreciate the wisdom. Thank you.
Yeah, thanks, Karl.
Well, I appreciate you for having me. And if you ever want to discuss some other things around these rules, maybe we dive in a little deeper on another call.
You bet, man. Thank you, sir. We'll talk soon.